as you think about your business, you have to draft the terms of service, whether you're a B2B or a B2C company. And that terms of service is no longer something that you can copy from someone else or even have ChatGPT create for you, because it actually has to really dive into some of the key issues with respect to how you're going to think about protections and liability. I'm going to turn it over to my colleague, Tracy, to introduce herself. She's going to walk us through some examples and IP issues, both with respect to tools owned by companies as well as third-party tools and the use of those tools. And we're then going to actually have a great conversation with Pra Chandrasoma, who is a in-house counsel at BENlabs virtually, which I'm excited to do. And then you don't get to hear from me anymore after that. You'll have other lawyers at Fenwick take over. But let's get going. Tracy.
Yeah. Thanks for coming today, everyone. Glad to see everybody in person, and welcome to everybody who's virtually a part of this presentations today. We're going to talk about, as Vejay said, go through some key compliance components related to terms of use. We're going to provide a quick dive into the key considerations. The idea is to talk about things you should be thinking about as lawyers when you're updating your terms of use to account for AI-generated functionality or preparing a new terms of use for your business, for a part of your business. So let's. So I think a baseline consideration for you when you're thinking about preparing terms is if you're going to use third-party AI tools as a part of your offering to customers, it's important to consider your business's role. We heard some of this in the first presentation, but as you think about the content of your terms of service and the approach to liability and risk mitigation related to terms, you think about your role in the ecosystem, about what type of business you are. Using chatbots or other tools will implicate a range of contractual issues and considerations for your terms and conditions. So a theme that was mentioned in the last panel was, if you're a financial services provider, you'll want to have a closed loop necessarily where the data and content remains under your control, or at least consider carefully doing that because of the value of that data to your system, but compare that to the structure of a structure common in a social media platform where the user's in charge of their content. Those types of things will impact your relationship to your terms of service.
Yeah, I mean, I often, I don't think our form does this, but I often, when I'm reviewing a terms of service that someone's prepared, I often sort of talk to clients about, let's put a description of your service up front. Now, we're going to talk a little bit about this later with our in-house colleagues. You want to have some flexibility too, right? So you don't want to sort of box yourself in on what you can and can't do, but having some sort of description of your service is helpful for a consumer to understand exactly what you're offering them in that context. And so whether you're a social media platform or a publisher, this is what we do. This is how we think about this. This is what our service is. I think, at a baseline, that's a really important first consideration. And then we're going to dive now into some of the details of that as well. And obviously, if you use third-party tools, and we're going to show you different examples of this, you might have pass-through provisions that are key or critical as well, or you might be using third-party tools that put burdens on you that you may or may not want in that context as well. So we're going to talk about that.
So this, I'm very proud of this slide, gives a slice of the ecosystem. The idea is to show, am I doing it? Okay. The idea is to show you elements of the considerations that you're going to be focused on, right? A lot of my practice is right now at the application layer, specifically where I'm advising clients that are leveraging or powering their applications with these different AI tools. Training data we're not necessarily going to talk about today, but it's a part of this feature. It's a part of the ecosystem, something that you need to be concerned about. Mostly I'm going to be talking about, the application, the input, the output, the relationship to the end user consumer. And this gives you some examples of, the types of input and outputs that you need to be thinking about. I think that, it was also mentioned that this, from my perspective, is where all your issues are, right? And we're going to talk about some of them, but I can animate it too by going back and forth. But the point is that you are really at a point where you need to sort of do some creative issue spotting, and then think carefully about all the different places where you could have, these areas to me represented IP issues, but, for you as the in-house counsel supporting your business, you're sort of here, and this is where we want to focus. Did you have anything? Yeah. So what I did was, I took one of my clients and removed the names so that we could talk at an example and really get into some of the language. So I'm quite proud of the irritation of my daughter, because she was like, how could you take a kitty and make it look like a dog? But this is what DALL-E produced for me with my text prompt. And so I was able to create this image, but the name of the company, I'm going to call it Image Pow. And we'll just walk through an example and talk about some of the issues that were relevant for them. Image Pow's offered an AI-powered image-to-avatar camera app for video chats and live streaming, including text-to-animation services. An end user can select an avatar from an Image Pow existing catalog or create a customized avatar to use in the camera app while on video calls. An end user can also enter natural language text to modify the generated avatar, and the catchphrase would be transform into the you always wanted to be. So just imagine you're looking into your phone, and you're able to project another image of an image you'd want to be, whether is it a celebrity, or is it a something in the app provider's existing catalog of faces or personalities, and show that to the world, and then tune that image or the animation for that image. And Fenwick is, as you could get the sense from us providing the CLE, we're firmly entrenched in generative AI, and I personally represent several startup and institutional clients in the generative AI space. And so setting the stage with Image Pow as an early stage startup, and let's look at some of the language concepts that we dealt with for them. So first, we want to, and I'm going to talk about some selected issues here because there were plenty. You want to develop definitions to capture the features and functionality of your services. So just really briefly, Image Pow, we needed to think about, you can generally start off with input and output, but again, with that idea of, having a clear description of your services, tailor those definitions for what would communicate to the consumer reading your terms, but also, help to explain some of the trade-offs you're going to make in the agreement later on. So based on the image uploaded by the user, by its customization services, the Image Pow app generated an avatar that looks like the user or someone else. So this was the user image input. And we use the Image Pow app during video calls, allows the user's device camera to record the user's face, tune the app. We define that as user video input. And the user can also use a text prompt to modify the generated avatar, and the prompt is the oh so popular term, and whether your kid's going to grow up to be a prompt engineer or not, I'm not so sure. It'll still be there in a long time. We'll all really get good at this. But a natural language text content to instruct the generator to generate the AI output. So the input, the user content, that was the image, both of the types of images and the prompt, and then the output, the Image Pow content, would be the generated avatar and the real-time animation generated from the user's video input. So related to this functionality, the next step is to think about, well, what rights are needed for an app to turn a person's image into an avatar or to animate an avatar? So towards those ends, the next step would be to think about the IP rights strategy and ownership. Here related, this is where the impact of, well, what's the business model? You're generating avatars or code, or are you in a architectural work environment, if that's your business, and putting, generated content into those business framework. The point is to develop an IP strategy, IP rights strategy for the offering for the business, and then emulate that in your user agreement. So, quickly here, there's the highlighted language, the first bit, the copyrights. You needed those rights to use the submitted image. In the first iteration of the client's business, they were adamant that he was adamant that we couldn't access the videos that were recorded because they were locally created. But and really didn't want a license grant at all. Because it's not happening on ImagePow's servers and it's happening on the user's device, doesn't mean actually when the technology is running, you're not going to need a license. You're not going to need the ability to exercise some of these rights in the copyright. So there took some, a bit of negotiation with the client, but not convincing them, really trying to understand what their concerns were about, how they wanted to interact with their customers and thinking about their business model. And the bottom line that we, explained to them is like, you're modifying the user video input by collecting it or by having it put into the AI generator. So the creation of that derivative work, you need rights to do that.
Yeah, I would just add, I think we've seen, even when we talked about traditional social media, we saw some PR around when Instagram came out with its first terms of service. And so we've seen terms of service really is something that customers actually sometimes do read. And they do comment on it. It can turn into a PR issue as well as a legal issue. And so when you're thinking about this, think about the rights that you actually need versus what you might want as a pie in the sky approach. You'll see besides the highlighted language, it still says for user content in connection with operating, provided, and improving the services, right? It doesn't necessarily say that they can use it for other purposes. So I think it's sort of the scope of the rights is sort of important as well to make sure that you're defining them correctly. And then you see at the end, for clarity, when you use the services, your user image input is used to generate the avatar, which is a purpose, as well as the development of our statistical models to allow us to improve the quality and performance of our avatar generators. Again, it doesn't say they can use it for other purposes other than improving their own service, which is pretty typical. Now, in social media platforms, you'll see broader language sometimes, and you'll see sometimes the ability to promote, the service or the business as well. So we often have discussions with our clients about the scope of the rights that they want. And not only does it, whether or not it makes sense from a legal perspective to operate the service, but whether or not it makes sense with respect to who their consumers are and what their consumers are going to expect from a transparency perspective. And this is the language that people will look for. And we live in a world of, internet trolls. And so this is what they look for and this is what they talk about. And so, again, I think it's important to kind of focus in on this particular provision for many purposes from a business and legal perspective.
And to put a period in that, the client here was really concerned about making sure that their end users had comfort around the terms, but the reality was that some of them would create some discomfort. But so we ended up creating a list of things that ImagePow's users may be concerned about, and said that ImagePow didn't do those things. Just another technique in terms of bringing the end user closer, making sure there's no confusion and or at least trying to eliminate confusion. So another piece of your IP rights strategy discussion is the ownership of the output. ImagePow also took the position that it would own all the output. The pre-existing avatar images went in and were coming out on the other end, the generated avatar and the animation generated by its services. The license back to the user concept is another one to consider, where ImagePow granted a license back to the user to use the ImagePow content for commercial purposes. This is about, what about the image that's generated? Does the client want to say, I bought the perspective from the in-house attorney thinking about this, does your internal clients want to say, we built this powerful tool and I want to own the output? We'll get to the limits of the ownership stance momentarily, but still consider it as a part of the overall strategy discussion. In this case, the ownership of the output wasn't controversial from the client's perspective because it was a free service. It was attractive to the client to maintain some control over the content, at least theoretically, contractually. So if the user did something the client didn't like down the line, using the service to harass or defame someone, to them, they wanted to keep the right to revoke the license. Other clients of mine have also taken the ownership position with respect to the output from their AI-powered services, finding that the work that they put into developing the, either the model themselves, because we've got clients, sort of with both sort of business models under their umbrella, either creating the model themselves, processed by their services, or their processing services, all gave them the right to protect their interest in the output and not to provide the user with the ownership of the output, albeit generated from the input provided by the user. Vejay, you and I were speaking about how this is so parallel to SaaS and cloud services, and not a different issue.
Yeah, I mean, I think on the B2B side,
use that one too.
Yeah, I think on the B2B side, you're going to want to own the inputs and the outputs pretty much, right? So you're going to have a lot of concern over use of your output. You're going to think about competitive concerns. That was brought up by my colleagues in the earlier panel. On the consumer side, I think that's the conversation you want to have as a business. Do you really want to take ownership of the output? Is that something that you think your user won't mind? And does it make sense for your business? And I think in certain free entertainment contexts, it makes sense. But for the most part, I think it probably isn't the right approach. I think ultimately users, creatives expect to put something in, get something out, and sort of use it, and they think they own it, right? And so we all, as lawyers, think about inputs, outputs, copyright, derivative works. None of that is on the mind of a consumer, right? They're like, hey, I'm using this service. I created something cool. Now I got a new cool thing that I own, right? So that's something that we talk to our clients about. And again, when I talk about clients, we talk to our in-house clients about this from a legal perspective, but we also talk to founders, CEOs, and CFOs who don't have lawyers. And so as in-house lawyers, I think it's important to have that conversation of, does it really create value for us to own this output or not, right? What position do we want to take vis-a-vis our customers? I think it's really a critical question to be talking about upfront before you build your terms of service. To think about both the inputs and outputs and how you want to allocate IP and ownership with respect to your relationship with the consumer that you're engaging with.
Yeah.
Okay, you don't have to trade anymore.
Right. Sure. So, and to the point, I mean, maybe I just spend one more second on the prior slide, but the position of the U.S. Copyright Office will be covered in detail in the CLE presentation following this one. But there was a lot of discussion for, I do have clients still taking the position that they want to own the output, and we have to have that discussion based on what the law is saying at or what it is the environment is saying at the time. But we did, what's the approach of other generative AI tool providers in the market? We've got a helpful slide that follows this one, but in short, AI tool providers generally state or imply that the user retains ownership of the input. Output, for the output, most AI tool providers allocate ownership of the output to the user. I think you were talking about ends up being more reasonable. But, however, while the provider's TOS can state who owns the output contractually, the ability to protect and enforce the intellectual property rights associated with that output depends on applicable laws. And that's the Copyright Office.
Yeah, and it's kind of about whether or not your user is going to care, right? I created a Midjourney image of my dogs. I threatened to sue everyone in this room for property violations, but I didn't really care, right? So if your user's not going to care, then maybe it's less of an issue.
Fair enough. And then with respect to the other AI tool providers, the license or grant back of rights to the provider. Under most AI tool provider terms, the user grants a broad, often perpetual license to the provider or right back to the provider for both the input and the output, with the provider having the ability to further modify such input or output. That is the, going back to my client example, that is the approach that they end up taking. While in some cases the license or the grant of rights back to the provider is limited to operating, improving, and or training the AI tool, still needed to provide language to explain that to a concerned user, what that actually means. I think it's very common or understood that there's a training going on and maybe not so much as a standard, enterprise users, enterprise scenario or business model. But I think when AI is involved, there is some understanding that there may be some, especially in the consumer sense, that there may be some training of the tool.
Yeah, I think you're going to see sort of, you saw the incognito approach recently this week. I think you're going to see that more, which is, giving users a choice whether or not they want that data to be input for training purposes. Again, I think it's going to be a decision that companies need to think about in terms of who their consumers are. There's privacy implications to that we'll sort of touch on later. And there are privacy slides in your CLE materials as well, because unfortunately we don't have time to do a deep dive on that today. But this slide sort of key considerations, I'll turn over to Tracy in a second, for the various terms that we see in the market currently, and they're a little bit all over the map. So Tracy, maybe you can comment on sort of what you're seeing here across different platforms.
Yeah, it mainly reflected the summary slide that I had, and this is a snapshot with the the user owning the input and the user owning the output, and speckled through whether to the extent permitted by applicable law being the phrase that we see, and also that I suggest using in the terms once you've had that discussion. Were there any particular ones that you were interested in?
No, I mean, I think you see a little bit of you see sort of the ChatGPT approach. I think what I had mentioned, I think it will be more of the standard approach. But you also see various licenses. You see different potential components of if you're buying a certain type of subscription, then there's a stealth feature, right, in the Midjourney, and so
or a user's right to opt out.
Correct,
right?
And so I think you'll see more of those types of optionality for users to have more control over their experience. Again, I think if you're a free-to-play sort of product, maybe there's less of this type of language and terms and optionality, but I think users are more sophisticated. Regulation is becoming more sophisticated on these issues. I think you're going to have some thought put into how you approach this from an AI platform perspective, because I think it's an important issue. I think one thing I'd love you to comment on, Tracy, is sort of when you think about using some of these tools. If you're a user of these tools or adopting some of these tools as a company, what are some of the issues that sort of we see with respect to those terms?
Wouldn't you know, the next slide we start to get into.
Didn't memorize this?
Okay. Where I was like, is this a... So using third-party AI tools, important consideration, and you want to evaluate the terms of the AI tool providers providing your services, right, or powering your services. There's a phrase I use. But in addition to analyzing the ownership and license back, you're going to scrutinize the AI tool providers' terms for restrictions and other requirements that can impact your user relationship. So where we saw this with ImagePow, they use derivatives of Stable Diffusion's text-to-image AI generator to power its image generating layer to create the avatar's output by the app. ImagePow's own TOS was impacted as a result. So what this is that Stability AI licenses Stable Diffusion under its own terms and those of the Creative ML Open Rail M license. Let's just call it the Rail license. The Open Rail license, though, and similar to open source agreements that do this, but requires licensees that reproduce and distribute Stable Diffusion derivatives to include certain notice provisions, include usage restrictions in their user terms, and notify users of such restrictions via attribution, provision of a copy of the license, and notice of any changes to the model. So all of that it can have an impact on what your relationship to your end user is going to be. You want to check for these usage restrictions. The agreements have some to some degree. Would they permit commercial use? You don't want to find that out as an in-house attorney after the product's been built. And for some of the startups that I've been dealing with have been a bit more flexible, but at the same time, they needed to then put into their terms of use specific language regarding the presence of the derivatives. But even more importantly, we need to evaluate for them and walk them through the various use restrictions that needed to be included in their terms of use because of the use of Stable Diffusion. For all intents and purposes, everybody's going to be on board with, don't use derivatives for illegal purposes. But some of them, I don't think, not always lawyers write it correctly, but the Rail license has some very vague and ambiguous language in it that if you want to use their derivatives, you've got to put in your terms. So things like, one of them, and let's see, to generate or disseminate verifiably false information. Okay, that sounds clear, but fully automated decision making that adversely impacts an individual's legal rights, I'm not so sure. Or for any use that has the intended to or which has the effect of. Those having to make the sort of proposition to your consumers, you need to make sure that you're on board with whatever those requirements are. And for an app that helped you hide your appearance, to have a prohibition against impersonating or attempting to impersonate somebody, well, that's going to have an impact and maybe undercut your value proposition, which was a part of this client's business. So a lot to consider there. Can you live without that tech? If it's the only image powering option for your AI offering, it's going to have an effect. And while you may be able to build quickly because these tools are so amazing for that, it's going to require an important workaround. So the good thing is we've put this in the materials for all you guys to take a look if you haven't seen it yet. So this is an example of being pretty careful and thoughtful about the agreements that relate to that are ultimately going to relate to your offering. So this next slide, just to sort of sum up, and I wanted to create a slide to go through some key considerations. We could devote, discussions to all of these areas. Some are fundamental to just providing, having a content-based business, right? General use restrictions. You don't want any content of people you don't have the permission for, prohibitions against activities relative to your service's functionality. You want to make sure, like we said, about flow down requirements. One that I want to mention that, particular to the hallucination that the output of these services can have, the hallucinations being just wrong, not factually correct. You want to make sure those things are contemplated in your warranty disclaimers. No guarantee of accuracy, truthfulness, or reliability. Another one that's particular to the AI is the acknowledgement of certain service limitations, and one is the similarity of output. A characteristic of certain of these AI generator systems is that you can put in a prompt But that doesn't mean that someone else isn't going to end up with a very similar output. And there's some example language that you see in some of the main AI tool provider agreements, but I recommend adapting for your terms of use as well.
Yeah, I mean, I think that's language probably goes in both B2B and B2C terms of service. Ultimately, on the B2B side, you'll see that negotiated. I was just recently working with a client using an AI tool, and we sort of started to get to sort of, okay, if we hit 80% accuracy, we'll sort of hit the next milestone and we'll move forward with a real engagement. And so obviously customers who are paying you to provide the AI may have different expectations of how it will work, similar to a service level agreement in a B2B terms, but in a B2C context, you're going to go for the broadest disclaimers that are permitted by law. And I think it's important in the AI context to have specific disclaimers around the results. Obviously in consumer products, you think about sort of different disclaimers in that context. And again, it's very business specific, whether it's a game or a consumer product or an enterprise tool. But those are things to think about. Again, I think if you have a form terms of service that doesn't approach that from that angle, you may or may not actually limit your liability in ways that are will really potentially hurt your business, because this is the real contract you have with either your customers or in either in the business or a commercial context. Arjun touched on this a little bit in the last panel. Having a DMCA policy is sort of critical, particularly with respect to content. Whether you're an AI platform and you're thinking about ingesting content, or you have some sort of entertainment application that brings in third-party content, right? And so you may or may not have rights to that third-party content. Again, this becomes a very traditional legal analysis. You have the user represent warrant that they have the rights to that content, but they may or may not actually have the rights to that content. And so having DMCA policies and takedown procedures makes sense. I think Arjun made a great point about sort of thinking about what that policy really is. There have been cases out there with marketplaces with respect to trademarks, right, at publicity in other areas as well, where some terms of service include some of those issues as potentially takedown as well. Even if it's not technically under the Digital Millennium Copyright Act from a news standpoint, they still have a process for those claims. And I think as a platform, given AI has multiple potential IP implications across that spectrum that's been touched on already today and will be drilled into in the next session, I think having a broader policy in place for understanding how to manage third-party content is really critical. And having the right language in there is critical, both from a legal standpoint to ensure that you can have potential immunity, but also from a policy perspective of how are we going to deal with this? What are the resources we're going to allocate to this? And having conversation with your outside counsel of where those lines really are. Are you doing too much from a moderation perspective, or are you doing too little, right? There's definitely some lines there that I think you need to sort of tread carefully around, and sort of, it's a little bit of a balancing act, but important one. So.
And I have clients that are receiving requests to remove them, certain content from their generating, or they don't want to turn up in the output. And I think that having a process available to handle that is important. It's not DMCA necessarily, right? But it's hallucinations, incorrect information. Folks are going to want to have some sort of way to reach you about and how to deal with that. That can go a long way to getting you out of the PR cycle. So I think, we really want to have a conversation with Pra.
I think we touched on privacy earlier. I think a lot of the key takeaways we gave you sort of still apply across that area. I do think that will be an area of more enforcement ultimately going forward. We do have some takeaways here. Strategize with a human lawyer. I saw that. On your product and what's important to you. And I think we talked about developing definitions and analyzing the proper terms. But we do have materials for you in the CLE materials with respect to privacy. And now we're going to take a little bit of a different approach and actually have a virtual conversation, which I'm hoping works out technically, with one of our clients on how they think about these issues. And hi, Pra, can you hear us okay?
I can hear you great. Hi, Vejay. Hi, Tracy.
Great to see you. Sorry, I can't have you here in person, but great to manage this virtually as well. Pra is a human. And maybe you can introduce yourself, Pra, and tell us a little bit about what you do at Ben.
Sure. Yeah. It's great to be with you all virtually. Wish I could be there in person. But I'm Pra. I work at BENlabs, which is an AI oriented social media optimization and entertainment marketing company. And so when we put all of that into more plain English, entertainment marketing means that we help clients integrate their brands into content of all different sorts. So you have GM cars turning into, fighting robots in the Transformers movies. That was us. And you have your favorite influencer on TikTok, plugging a product. We may have done that too. So we sort of run the gamut of content. And on the other side, we have a sort of a B2C offering, which is a social media optimization tool called TubeBuddy. TubeBuddy is designed to analyze both structured and unstructured data in YouTube content to help creators create content more effectively. And when I say more effectively, I just mean to create content that generates more robust engagement, buy-in with their audiences, and achieves their goals in more intelligent and direct ways. And the link between both of these businesses is our proprietary AI algorithm. So we have an analytical AI tool that analyzes a whole wealth of data in all different forms of content to provide us with, whether it's on the B2B side, optimized brand creator matches, or on the TubeBuddy side of the business, optimized intelligence about your content and what's worked and what hasn't worked in order to help you produce more effective content and constantly optimize what you're doing on social media as a creator. And I'm the AD here, so I do a little bit of everything, but I'll pause there.
Yeah, I mean, so you're AI is not a new rodeo for you. Tell us a little bit about TubeBuddy. When you acquired it, to the extent that you can, obviously, tell us a little about, you had to think about their product, how it would work and integrate with your company, but you also had to think about some of the issues that we just spent a lot of time on with respect to data, IP, inputs, outputs. How did you sort of think about that from an acquisition standpoint and integrating that product into your business?
Yeah, it was front of mind for the entire acquisition process and remains front of mind in the day-to-day today for us. I think one of the problems of running a business that integrates with social media platforms is you have to be responsive to a multiplicity of different stakeholders. We have to, as an in-house counsel, I have to be responsive to the needs of our business to continue to offer the product that they want and sell it in the way that they want to. We have to also be transparent with our users and ensure that they have clarity about what the platform is, how it works, and what we do with the information they give us and what information we're actually gathering. And we have to sort of weigh that again with a third stakeholder, which is the platform itself. I mean, we have to do all of this in a way that plays by the rules of the platforms that we operate on. And obviously, YouTube has fairly Byzantine terms of service and API terms and privacy terms and all sorts of rules that really make the game challenging to play. And so, we had to think through all of this. And when we acquired TubeBuddy, obviously our main value proposition was to incorporate our AI tool into this really effective product, which added an entirely different layer of complexity to an already pretty complicated landscape. So it was something we thought about a lot from a business standpoint and a synergy standpoint. But it's also, something that's remained kind of at the front of our minds as we continue to optimize and iterate a product. Because, when you serve a dynamic population like creators on YouTube, their needs are always evolving, always changing, and you really need to be sensitive to them. And so, our work is never over, and we're always trying to figure out ways to optimize the product and introduce new features. And every single time we do that, we have to think through these issues almost from scratch.
I mean, that's a good point. We talked a little bit about consumers and their expectations with respect to their content, but creators who I guess you could talk about it, as a B2B customer in a way, right? They're a little more sophisticated. They're creating content. They care about what the ownership of that content is. It's a good point in terms of how you have to think about the language that you use in your contracts, in your communications, in your terms of service with those types of creators. Lots of our clients, for example, have asked me to put it in maybe one or two sentences. You own this, I own this, and call it a day because they really don't want to overcomplicate it. How did you think about that when you acquired TubeBuddy, when you looked at their terms of service, when you sort of had to sort of modify it with respect to the integration of your AI?
Yeah, I mean, I think one of the things that we noticed right away was, and sort of we're sensitive to this across our entire business, is that in our world there are a lot of different parties who want to claim rights in data, and the rights vary, but you sort of have to balance your pressing business interests to get the rights to use the information that you need. I mean, our AI, eats information, right? That's what sustains it. And so we need to have the rights to use and leverage the data that we generate in order to continue increasing the intelligence of our tool. At the same time, we have to balance that assertiveness against the interests of other parties in the arena. And we want to avoid situations where we're being so extroverted in our assertion of rights that we run up against the interests of a creator or let alone our entire community or the platform again or the platform. And so it requires sort of a deft and light touch, and it's a balancing act for sure.
When I was in house, I remember thinking if I was going to say no, I wasn't invited to the next meeting. And so you had to find solutions to sort of think about how to interact with the marketing team and work with them seamlessly. And, while the marketing team, can be sophisticated, they also want to accomplish something, right? And so how do you work with your team in terms of balancing some of the things that you just identified, making sure that the product really can have the data that it needs, it can improve, it can optimize, but also sort of thinking about some of the other participants in the ecosystem and the legal backdrop that's slowly sort of becoming more regulatory in nature as we move forward?
It's a great question, and I think it strikes at the heart of a broader tension that exists between the business as a whole and the terms of service, because a lot of times the business can view the terms of service as introducing constraints. But the way I like to frame it for my teams is that, it's really not constraints so much as it is memorializing a set of trade-offs and articulating our shared priorities. And what I mean by that is effectively you can't get one thing without giving something else up, right? So we can't, for example, have the flexibility to do everything we may ever want to do with the business without making our creator community feel uncomfortable about the vague nature of the rights we're granting ourselves, right? And so you have to balance these interests. And I think a lot of times the way that you can negotiate these tensions with your business stakeholders is to say something to the effect of, you have this goal, but if you zoom out the lens a little bit, you can see there are actually multiple priorities that we need to make sure we're reconciling properly. And you don't want to throw, one baby out with this bathwater. And so, I think, teams can often get tunnel vision when they're solving a problem. And I think one of the roles of an in-house lawyer is to ensure that we maintain this sort of broader perspective and keep the broader strategic vision in play. And I think when you do that, it also just communicates to the teams that you're not just being sort of an obstructionist, nerd, and you're really trying to focus on broader strategic initiatives and ensure that we're not cutting, that the right hand and the left hand sort of know what one another are doing.
Yeah, I've never been called an obstructionist nerd, at least to my face, maybe to my back. But one thing you said I thought was interesting is you have to think about sort of what the risks are going forward, but it's also about the adaptability of the product going forward, right? As lawyers, both outside and inside, and if you're doing this right from an outside perspective, you're asking your client, where do you see this product going in 6 months? Where do you see it going in 12 months? How do you think about that with respect to Ben or what you're seeing right now and sort of the overall AI marketplace with respect to entertainment? Yeah,
I think flexibility is the name of the game. I think when you have a product like ours, it's really probably our top priority is giving ourselves the freedom to create, new features, to optimize existing features, to make improvements to the product without having to overhaul the terms of service every time we do it. And, I mentioned before that does come at a cost because you necessarily can't be as transparent with your creator community or your user base when you are trying to give yourself the room to maneuver in the future. And that, from our perspective, I think is a sacrifice worth making because I think what our community cares about above all else is a quality product, right? They want a good service that's improving and responsive to their needs. And I think, we're sort of willing to bet on them being understanding about us giving ourselves the room to be responsive to their feedback and their needs. even if that comes at the expense of complete and total clarity. But having said that, we always try and give ourselves flexibility while preserving an intent to not be sort of inherently unclear or intentionally unclear about what we're doing. We don't want to be sort of nebulous on purpose, and we're not trying to confuse people or hide the ball. But flexibility is the priority for us, and giving ourselves the room to have this product grow and continue to serve the community that we care about is really, really important for us. And so that's always going to be what drives us, and it's going to be the first thing we think about as we craft terms of service.
So tell me about that. Like, terms of service sometimes can be a checkbox exercise for some clients. And we as lawyers often figure that out pretty quickly, how much they really want to dig in with us or not dig in with us. But how do you think about it in terms of how important it is to the business, how you think about working with counsel on such a project? I know we're in the middle of one right now, but which we're not going to talk about today. But how do you think about sort of the process in that context?
Yeah, I mean, for us, it's not a checkbox at all. I mean, I think of it sort of as our department's statement of purpose in terms of what we see the business being, and we view it as a way for us to share with our community and share with our customers what we're giving them, and to be real and transparent about the costs and the trades. Because ultimately, again, like I said, that's how we network. It's a really, really detailed description of the commercial exchange, of the value proposition. We're giving you certain outputs, and you're giving us certain information, and we need certain rights in order to continue to give us this product that you care about. And so, for us, it's really it's about defining our relationship with our customers. It's central to our business. It is the source of truth for everyone who cares about our business to come learn about what it is that we do and how they will interact with us. So, there's this weird sort of intimate element to terms of service for me, that I think, are incredibly important at establishing and sort of acting as a foundation stone for community trust.
Sounds constitutional.
Yeah, I mean, that was the perfect answer, I think. But last question, and we really appreciate your time today. Whether you're using AI in your product or you're using it as a tool for productivity, and we've touched on both. How are you prioritizing as an in-house lawyer right now with respect to the tasks that you need to get through? Right, you have employees who may be wanting to use AI tools. You have AI in your product. You need to think about inputs, outputs, data. You're thinking about regulatory framework on top. What's the priority for you right now?
I think I sort of think of all of this. It's like so many other things in the life of an in-house lawyer, especially at an early stage startup with a lean team. You sort of run it like an emergency room. You have to triage the most urgent needs and care for the patients that are really, really sick first. And I think, for us, our product is at the center of everything. And so, if it's a tool that is integral to the advancement of our project, and you all alluded to this before, if it's a tool that's integral to the advancement of our product, and it's something that we can't replace, we find a way to make that work first. That's the first priority. I think the second sort of priority would be things that are the sort of nice to haves from a product standpoint, the tools that are helpful and would save us time in terms of developing sort of a replacement option in-house. Those are sort of a second priority because we feel like we have that fallback position of developing something in-house. And then, sort of the day-to-day sort of, Slack message you get at, on a random Tuesday afternoon saying, hey, I want ChatGPT to write a pitch for me. Can I do that? Those are lower priority, right? And so, I think, for pure convenience and curiosity, we're happy to see our team members being curious about AI and stuff of that nature, but it's not a priority. And I think above all of that sits, our own tool, and protecting that is of paramount concern to us, right? Because it is the red beating heart of our business. And so, I think that's how we sort of rank order things. But I think, as I say that, I know that there are moments where you have to be willing to say, well, the rank order isn't as rigid as I maybe said it was. And, we have to be willing to make exceptions or to make accommodations for the team in circumstances that are exigent, or to support, to support them in not missing a launch deadline or or whatever it may be. There are always business goals that might trump the sort of best laid plans, and you just have to be ready for them. So I sort of can outline the broad things, but I'm also glad that nobody from my business team is watching this, because they would probably hold me to that more than I want to be held to it.
All right. Well, we know you have a busy day ahead of you, so we're going to let you get back to it. And we appreciate your patience as we got a little bit late running, but hopefully that was helpful to everyone. I really enjoyed that conversation, so thank you so much.
Thank you all. Yeah, really great time. Appreciate you.